I just want to say aloha and welcome you to the section on Act 48, Foreclosure Law Update. First, I'd like to make an announcement. In the handout that was sent out to you, the brochure that you picked up, it indicated that this was a presentation from the DCCA panel. It is more than that. It is a panel representing the DCCA, the judiciary, HUD, the banking community, and title and escrow services. We apologize if there was any misunderstanding. I'm Brian Benton, Chair of the Government Affairs Committee for HAR. You know, the American dream has always been that of home ownership. Several years ago, Congress pushed for more open lending policies to make that a dream more of a reality. Some irresponsible lending policies and practices pushed home ownership on people who were really not capable of paying their mortgage. No-doc loans, financing in excess of 100% of the property values, and the housing bubble got bigger. People got second, third mortgages in some cases, and lenders made some of these loans with little regard to reality. Then the economy collapsed, property values dropped, and this was not just a U.S. phenomenon. This was a worldwide event and therefore difficult to resolve, as we still see in a timely manner. In this session, we're going to learn about the most recent developments in Hawaii's foreclosure law, implementation of Act 48, understanding the dispute resolution program and title insurance policies with regards to Act 48. First and foremost, allow me to introduce how Act 48 came about. We were all aware of the concerns of homeowners who were involved in circumstances where they had issues with a possible foreclosure. The primary purpose and intent of Act 48 is to require DCCA to facilitate a dispute resolution between the borrower and the foreclosing lender in an attempt to avoid foreclosure where possible. Lack of timely communications, no response by some lenders, and in some cases foreclosures without proper due process was part of the horror facing homeowners. Several states and municipalities have mandated dispute resolution for the purpose of avoiding foreclosure or mitigating damages when foreclosure is inevitable. Many of these programs have been successful in allowing families to remain in their homes or coming to solutions that reduce damage to the homeowners and the community when foreclosure is the only option. Panel members here are to inform you and educate as to what to do from here on out. And here's a brief overview of what the panelists will cover. Everett Kaneshige will provide an overview on Act 48 with new policies and practices that DCCA will be involved in. Patsy Saiki will cover policies on foreclosure, product policies as they relate to title insurance. Gary Kawamoto will address loan mitigation, loss mitigation, loan modification, and short sales from the lender point of view. Gail Ota will cover various procedures when loans go into the distress mode. And Elizabeth Kent will provide tips on making the dispute resolution session effective. Now let me introduce the panel. From this point here, Everett Kaneshige is currently Deputy Director of the Department of Commerce and Consumer Affairs for the state of Hawaii. Everett was involved in Hawaii's real estate industry and the technology industries for 20 years as an attorney, businessman, and entrepreneur. He was previously president and CEO of Pocket Real Estate, a company he co-founded which created the concept of accessing multiple listing service data via wireless devices such as PDAs and mobile phones. Patsy Saiki is currently Senior VP and General Counsel for First American Title in Hawaii. Prior to joining First American in 2004, Patsy practiced commercial real estate, financial services, litigation at the law firm of Watanabe King and Kawashima. In 2004, Patsy joined First American Title as its in-house counsel and as agency manager. Since then, she has held various positions at First American Title, including sales manager and general counsel. Gary Kawamoto is Assistant Vice President with First Hawaiian Bank. He is with the Credit Center with over 18 years of mortgage service experience related to default, foreclosure, and loss mitigation activities. And Gail Ota is a single-family program specialist with Housing and Urban Affairs, Housing and Urban Development. She provides single-family technical support for the Honolulu field office, performs home ownership center-wide nonprofit approvals, rejections, reviews nonprofit compliance reports, recertification packages, conducts housing counseling on on-site monitoring, conducts training sessions for the mortgage industry, as well as guest speaking at functions sponsored by the local industry. It's a big job. And Elizabeth Kent has been director of the Hawaii State Judiciary Center for the Alternative Dispute Resolution since 1996. Elizabeth taught business law at the University of Hawaii at the graduate and undergraduate levels for 6 years. She is one of Hawaii's Uniform Law Commissioners, is one on the drafting committee for the Uniform Mediation Act. We get a hand for our panelists,
please. Okay, good afternoon, everybody. On behalf of myself and the panelists, thank you very, very much for inviting us to speak today. You know, I look out at this crowd, and there are a lot of familiar faces. As Brian mentioned to you, a lot of you know that I was involved with Pocket Real Estate, and I did a lot of presentations to groups like this. I also represented real estate clients and had the pleasure to provide legal advice to them. I've also, many of you know, I'm also a realtor. I had my license until I took this position, so a lot of the issues that you folks face are very near and dear to my heart. And just this group alone, I look out there, there's college, there's college classmates, there's high school classmates, there's all sorts of folks. So I feel very much at home. Allison, don't duck. She's a younger high school classmate than I am. On the one hand, as you all know, we license all of the real estate professionals, so we feel that we have a duty and a responsibility to look out for that industry. We also regulate the financial institutions, so we also feel that we have a responsibility and a duty to look out for that segment of the community. And last but not least, the Office of Consumer Protection also falls under us, and so we have a very strong mandate to protect the consumer. So really, when we look out at that landscape, we felt that we needed to have something that really sort of addressed all three of those constituencies. And we didn't see that as those bills were going through. So late in the session, what we did was we crafted a bill that really provided for dispute resolution. It was, and Elizabeth doesn't like it when I use this word, but it was sort of like mediation. The idea was to bring the owner-occupant and the lender to the table to try and work out a loan modification or some other resolution so that people wouldn't lose their homes. And it was a very, well, I thought it was a very discreet bill. It was 25 pages. It was simple. It was straightforward. We submitted it to the Senate. And then something funny on the way happened to it on the way that it went from a 25-page bill to a 104-page bill. Because the legislature decided to add a number of other provisions to it. And that's okay, because the bill that has now been signed into law as Act 48 really does address a lot of different aspects relating to foreclosures. There are lots of parts to it that frankly individual stakeholders don't like, but all in all, I think it really does fulfill a necessary void by addressing lots of those issues and shortcomings that we talked about before that were really being complained about or testified about at the last legislative session. So for today's purposes, what I'm going to do is really talk about DCCA's involvement with mortgage foreclosures, which really does focus on the dispute resolution program that I just described. We're going to go through really the procedures for that. We'll answer any questions about that. The other panelists will talk to you really sort of tangential issues about Act 48, not necessarily related to the dispute resolution proceedings per se, and then we'll entertain any questions. Okay? Let's go. So this is the overview. Act 48 was signed into law last year. It is administered by DCCA here. See, this year?
You said last year.
See, time flies when you're having fun. I'm already into, and you know why? In my defense, the state has clicked into its new fiscal year, so that was last fiscal year for us. Sorry, folks. 2011. Okay. Anyway, what is the MFDR program? As I mentioned to you, it allows residential property owner occupants facing non-judicial foreclosure to meet directly with lenders to modify their loans or work out a payment plan. Now, there's some key words in there. The first one is residential. This program does not apply to commercial. It does not apply to vacant land. It does not apply to timeshares. It does apply only to residential properties. Second key word in there is owner occupants. Again, the purpose of the program was allowing people to stay in their homes. So the law has some very specific requirements for the owner to prove that they were owner occupants so that they would be eligible for the program. The third thing to look at, non-judicial foreclosure. I think most of you know what that is, but again, it is the foreclosure process whereby the lender uses the law to file a foreclosure that does not go through the court system. The law is very specific about how you basically file the notice and then you comply with certain processes which allow you to foreclose without going through the courts. And the last part with the concept is to work out a loan modification or work out a payment plan. I could also add that really the focus is to come up with a resolution in the best of all scenarios for everyone where you would still have the loan and the owner-occupant would remain in the property. You're looking at some kind of modification, you're looking at some kind of payment plan. But from a practical standpoint, we're building into the program a process whereby if the owner-occupant and the lender can come to some other kind of mutually acceptable resolution, that could be a short sale, that could be a deed in lieu, that could be something else, that could also be part of the program as well. Now, the last bullet is an important point. The legislature felt it was very important to allow owner-occupants to convert to judicial foreclosure if they received a notice of non-judicial foreclosure. Why did they feel that was important? As most of you know, probably as all of you know, there have been a lot of allegations about does a lender have the right to foreclose on their mortgage because the mortgage has been sold, because the mortgage has been assigned, because the mortgage has been securitized, all of these issues. And so if you're an owner-occupant and you feel that you have a defense in that area or some point that you would like to raise, if you get the notice of non-judicial foreclosure and you want to say, no, I want to go to court to raise those types of issues before a judge, you have the right to do that. But you have to do that at the beginning. You can't go through the program and then do it later on. Okay, important dates. These are the dates for the actual dispute resolution program administered by DCCA. It officially begins on October 1st, 2011, and it ends on September 30th, 2014. How do you know if you're eligible? Now, this is obviously, we've structured these slides as if we were doing this presentation to the owners themselves. A very important point about this is we get a lot of calls when the law went into effect. What can I do as an owner to basically avail myself of this program? And the answer is, you really, as an owner, you don't do anything. The way this program is set up is the onus is on the lenders who are going to foreclose to trigger the process. They file a notice of foreclosure just as they would have before Act 48 began, except now under Act 48 they have to file a copy of that notice with DCCA. What's going on? All right, anyway, they have to file it with DCCA. When we get the notice filed from the lender, that's when we go out and we notify the owner. A notice has been filed against you. You have certain rights under Act 48, under DCCA's program, to go through a dispute resolution process, submit certain documents, and to try and come up with the resolution that I talked about. The way we notify the owners is by a certified and regular mail. Now, one of the things that you might have heard about, this program is based on a program that was done in the state of Nevada. For anybody who listened to the testimony last year, or this past year, before the legislature, that was really the model that the legislature was looking at. In that state, however, for those of you who are familiar with it, they had a completely different process in the sense that the notice of foreclosure would be filed and then it would be up to the owner-occupants to opt into the program and decide that they wanted to participate. In our system, what's happened is basically all notices of foreclosure are filed with us, and then we notify the owner occupants, do you want to participate? So it's sort of the reverse of that. They have to opt out. And we'll get into how they opt out in a minute. So again, these are the things that we talked about a little bit. It has to be an owner occupant of a residential property. They have to live in the residence for a minimum of 200 consecutive days. That's in the statute, and again, it pertains to non-judicial foreclosures. Okay, this is a little bit of a hard-to-read slide, but I'll go over it real quickly. Once the lenders file the notice of non-judicial foreclosure, as I said, they have to notify DCCA. They also have to pay a $250 filing fee to us, and that basically triggers that second bullet whereby we have to notify the owner occupant. We have to do it within 10 days. We have to put down certain information about about the program, about the owner occupant's right to elect to be in the program. We have to include a list of approved housing counselors. And that's important because, as I'll get to in a minute, we're also requiring all of the owner occupants to go to counseling before they go to the dispute resolution proceeding. Now, the last bullet is the important bullet. Within 30 days after we give notice to the owner occupant, they have to decide if they're going to be in the program. If they decide that they're going to be in the program, they have to do three things. One is, there we go. They basically have to tell us they want to be in the program. They actually have to pay a non-refundable $300 program fee, and they have to certify that they're an owner occupant. Now, the question we usually get is, why does the owner occupant have to pay the fee? And the answer is, we really wanted to set up a program where people who go into the program really want to be in it. This is not a situation where we wanted to set it up so that it would just delay the process. So we felt that that was a fee for somebody who seriously wanted to work out a modification. That was something that they would be able to pay and they would be able to stand behind. On the other hand, if an owner occupant is delinquent and they're just not going to make it and they just can't afford it, $300 might as well be $3,000, might as well be $30. They're not going to pay it. That's one of the ways that they can opt out of participation. If they opt out, then the foreclosure continues. Okay. Again, these are just more requirements about the program in general. The highlights that I wanted to make, the lender pays a $300 program fee too. So what you see is that there was a filing fee that's basically paid to DCCA to cover the administration of the program. The borrower pays the $300 program fee, the lender pays the $300 program fee, and those are the fees from which we will hire the neutral to basically do the proceeding. And that's how this program is funded. It's meant to be somewhat self-funded. The third bullet is what I told you about the counseling. We felt it was very important that the owner-occupant go for credit counseling and budget counseling and housing counseling before they go to the proceeding. And that way, when they actually go to the proceeding and they sit down with their lender and they sit down with the neutral, that way all of their finances hopefully would have been somewhat vetted, and they really can negotiate in good faith right there and then, because that's the idea. They'll be there, they can try and work it out. We didn't want them to be in a situation where they show up at the proceeding and they've got shopping bags full of receipts and canceled checks, and then it becomes a big fact-finding thing. That's why that particular requirement is in there. Slide. After we receive after the parties decide to opt into the program, we then set up a hearing date or a session date within 30 to 60 days. We also, the sessions themselves, it says they allow for a maximum of 2 to 3 hour dispute sessions. Really the goal here is we're trying to do it in one session. If there's a situation where the parties are very close and it just needs a little bit more time to, say, get documentation from an investor on the mainland with respect to doing the modification or something else like that, the neutral has the discretion to schedule the second session. But really the idea is to do just the first session. So this is what's the big hammer to this? After the homeowner signs up to participate, the non-judicial foreclosure is on hold. Now, obviously right now, the non-judicial foreclosure is on hold anyway because the bill requires puts forth a moratorium until our program is up and running. But really, once our program is going, really the idea was that the hold or the stay, if you will, starts when the parties participate in the program. This is really what I just mentioned. You have the right to convert, but you need to do that before you go through the program. You don't get 2 bites of the apple, so to speak. If the homeowner decides not to participate in the program, we basically notify the lender that the case is going to be closed and the foreclosure process continues. These are other effects of Act 48. As I mentioned to you, there is, when the bill was signed into law, it contained a provision that put a moratorium on Part 1 non-judicial foreclosures. People ask what's the difference between Part 1 and Part 2. For all intents and purposes, everybody used Part 1 and nobody used Part 2. So the effect of it is that all foreclosures, non-judicial foreclosures, are stayed. Right now, the idea is once DCCA's program is up and running, then people will be able to do foreclosures through Part 2. And that's, frankly, we have yet to see how that's going to play out. There's some questions about what happens to foreclosures that were filed under Part 1 that were pending at the time that the law was passed. So we're trying to get some legal clarification on that. Other effects of Act 48, there's a section that deals with mortgage servicers that specifically require them to establish contact information and brings them under the oversight of our Division of Financial Institutions, so they're a little bit easier to regulate and contact. And there's also some protection against deficiency judgments. Now, what is that? I should have mentioned, most of you are familiar in a traditional judicial foreclosure situation. If you go through the judicial process, the property is sold, it doesn't generate enough proceeds to pay off the loan, then you've got a deficiency. And most lenders, definitely the local lenders, some other lenders will then go back to court and ask for a deficiency judgment to come up with that difference. It's up to the lender at that point whether they actually want to pursue that deficiency, but that is part of the process, and technically it is a judgment against the owner for that balance that wasn't paid off by the sale of the property. If you go through the mortgage foreclosure dispute resolution program, you are not subject to a deficiency judgment. So that is one of the incentives that we built into the law to try and incent the owner-occupants to go through our program. On the other hand, the other thing, what's in it for the lenders? From our standpoint, when we estimated from the beginning to the end of how long this process would take, we estimate with all the time frames about 110 to 125 days. That is far shorter in our estimation than it would take for a lender to go through judicial foreclosure, and that was the carrot, quite frankly, that the department felt would be something that would incent the lenders to also utilize our process. Okay. Again, these are just things that we counsel owner-occupants, and certainly if you have clients who are in a deficiency or a short situation, these are things that they can do. We will make these slides available to all of you folks through HAR, so all of the website information and all of the phone numbers, which are on the next slide, those will all be available to you. We also have folks that provide some counseling, or can provide you with some referrals when you call our department. We are working with the housing counselors to try and provide more information. And with that, I will turn it over to the next speaker.
The next speaker will be Patsy Saigi, Senior VP, First American Title.
Everybody who knows me knows I talk with my hand, so it's impossible for me to hold the mic. Okay, I will be brief because I think you all know that I'm available for you all 365 days a year. So what I've done is I have put together 7 things that I think would be helpful for all of you to know to help make these REO closings go smoothly currently and after October 1st when the new Part 2 non-judicial foreclosures take place. So I have 7 points. Okay, what is happening right now? 3 things. First, Everett talked about the moratorium on non-judicial foreclosures. Now, everyone at this point, most of you are familiar at this point that there are 2 kinds of non-judicial foreclosures in Hawaii, right? Those brought under Part 1 that Everett talked about that was much easier to comply with, and Part 2, which is much more consumer protection oriented. So as of May 5, 2011, when this law went into effect, all of the non-judicial foreclosures, I should say the vast, vast majority of all non-judicial foreclosures in Hawaii were conducted under Part 1. Okay, the moratorium on, or the hold on non-judicial foreclosures under Part 1 is on new non-judicial foreclosures until July 1, 2012. So the first big issue is what is a new non-judicial foreclosure and which ones can continue to close. So we did our own legal research. We reviewed the opinions of the legislature, and we came to a conclusion that if the affidavit of non-judicial foreclosure was recorded prior to May 5, 2011, when the law went into effect, we would not consider that a new non-judicial foreclosure. So just for those who have not done too many REOs, generally speaking, it works like this, right? Notice of intent to foreclose, public notice, public auction, sale to the highest bidder. If the lender uses the amount owed to it as a credit bid and becomes the high bidder, the lender can come on title. So within 30 days after that auction, the lender needs to record an affidavit of non-judicial foreclosure. So if that affidavit of non-judicial foreclosure had been recorded as of May 5, 2011, we are not considering those impacted by Act 48, and we still continue to close those. And there are still a lot of them. But please remember that the affidavit itself does not convey title to the lender for an REO. There still needs to be a recorded conveyance document from the lender to itself as the high bidder. So those of you who have experienced a little bit of frustration with the time it takes to put that lender on good title should all be aware that has nothing to do with Act 48. That is just the lack of familiarity with reporting processes in Hawaii. Okay, so the first thing, we are continuing to close existing foreclosures under Part 1 if the affidavit had been recorded as of May 5, 2011. Everything else is put on hold until October 1st when Part 2 is actually usable because the mediation program will be in place. So the second immediate impact of Act 48 was that it increased the amount of the condo AOAO lien after foreclosure. So for those of you who are not familiar with it, very generally speaking, after a foreclosure, a condominium association can impose a lien or assessment against the new buyer for, it used to be, up to $3,600 or 6 months, whichever is less. That amount has increased under Act 48 to $7,200 or 12 months, whichever is less. And that went into effect on May 5, 2011. So for REO purposes, when the lender gets on title, that amount does not get charged to the lender. But the lenders can and frequently do pass that $7,200 amount on to the next buyer in an REO. And that's a matter of contract. So just be prepared, because some people were expecting the $3,600 to stay in place. But because the law is unclear, the lenders are taking the position that it's $7,200. And just so everyone is aware, escrow is neutral, so we cannot get involved in that dispute. But more frequently than not, we're seeing that the lenders are saying that it is now $7,200. So if there was an AOAO delinquency prior to the foreclosure, that amount is likely to be charged to the buyer when they purchase out of the REO. That's the second impact. And the third one is actually not a change because of Act 48, but I just wanted to bring up that in order for, I can only speak for First American, but it's generally speaking industry standard that in order for the REO to be insured, we need declarations of vacancy from the buyer. And I will kind of skip over that unless people have questions because it's a very particular thing and we're a little bit, I have a little bit of time. Okay, so those are the two main impacts from Act 48 currently. Okay, so now, as of October 1, 2011, so the main, for us, complying with all of the new consumer protection requirements under Part 2, that burden is on the lender because we have to rely on the lender to tell us whether the lender conducted the foreclosure in accordance with the new procedures. So that burden is placed on the lender, and the lender will provide us affidavits of their compliance. But a couple of interesting things I wanted to bring up based on all the questions that come up during our closings now. First, which is a really good thing, under Part 2, the notice of intent to foreclose can be recorded in regular system and land court and has the same force and effect as a NOPA, a notice of pendency of action. Why is that really good? It's great because prior to this, when lenders were foreclosing under the non-judicial foreclosure process, many times they would not record the notice of intent to foreclose. And as a result of that, when you get if nothing is recorded, when you pull a title report, you have no way of knowing whether a non-judicial foreclosure is proceeding because the sellers you are representing in your short sales are no longer opening their mail, right? So we had so many horror stories of agents working and working on a short sale and just not knowing that a non-judicial foreclosure was proceeding. Now they will know because the notice of intent has to be recorded, and if it's recorded, it'll show up on a title report. Yay, good thing. The second thing is that under Part 2, the law is written such that lenders are now going to have to waive deficiency judgment if they go non-judicial. So it is now additionally an underwriting requirement. Prior to Act 48, we did not require that lenders waive that deficiency amount. Now it's required because it's part of the statute. Vacancy affidavits are still required, and I will skip over that because it was required before, required after. If anybody has questions, please come talk to me later. And the last thing I wanted to point out was that condo AOAOs still can non-judicially foreclose, but they are not subject to the mediation dispute resolution requirements that lenders are. So that situation we're seeing where condo AOAOs are quickly foreclosing and getting on title is probably going to continue and become more prevalent. So I don't know how many of you have seen it, but we're seeing more and more frequently condo, and that might be a good thing. I mean, condo AOAOs are home owners, right? Association liens are not getting paid, so it might be a good thing that they're doing that. But in any event, what we're seeing in REO closings is that the lenders foreclose quickly and get on title. So the answer to that, just because we see it a lot and people panic about it, if the lender's on title, they're just like anybody else on title. So if they were given proper notice and an opportunity to participate in this, their interest in the property should be removed along with anybody else who was properly served. So it should be a non-issue, except if you have to deal with an AOAO to get access if you're trying to sell it. So those are the 7 things that I saw for Act 48. Okay.
Next will be Eric Alonso, First Line Bank. Here, you want to speak from there, or you want to come?
I'm going to speak from there.
There you go. Okay, thanks.
I'm kind of lazy. It's 4 o'clock in the afternoon, and I'm kind of tired. But anyway, you know, we normally do a program at the bank, but normally we take about an hour to go through this whole, you know, loss mitigation process, everything else. I think based on the time constraints, we have between 5 and 7 minutes today. So I wanted to just bring up some key points of what banks do in terms of a troubled homeowner. You know, I mean, key point number one, banks don't like foreclosures. We don't want to do it. We have to add extra bodies. It takes a lot of time. I cannot play golf. I mean, it is one of these things that I just don't like to do. But based on our shareholders, based on regulators, we are forced to come out with some kind of collection policy or collection strategy that every bank, every servicing company in the nation is doing today. And literally, all of us have followed pretty much the same format. Okay, so I'll just go through some of the procedural things that banks today are looking at to help distressed owners. In the first, simplest phase, we're talking about a simple repayment. You miss a payment, I'll call you and says, hey, you missed a payment, what can we do? Says, well, can I pay you maybe one payment next month and maybe a little bit more? Can I pay you a payment and a third, payment and a half? And generally, I'll accept it. Okay, and it depends if it's reasonable or not. But a repayment plan is real simple. You know, it's just paying a little bit extra. Let's say you don't have the money right now, but maybe you're getting a tax return in 2 months. We call that a forbearance. I says, you know what, I won't bother you for the next couple months, but I expect to be paid in 2 months. So if there's a reasonable expectation that we're going to get paid in a couple months, or 3 months, or 4 months, it is possible to grant a so-called forbearance, and we're going to leave you alone till that 4-month period or 5-month period or whatever happens, and we're going to expect to get paid. Okay? That's the two simplest type of so-called workouts that bank, pretty much performs today. The third process we go through, let's say we cannot do a repayment schedule, we don't see any kind of income coming in. This term, modification, very nebulous. It is the most misunderstood term in today's real estate environment. And I'm telling you, I've heard stories and the horrors about mainland services and everything else. Modifications in itself actually was unheard of prior to 2009. Prior to 2009, you never heard of modification. It was the federal government that came out with their plan to say, hey, we're going to help the homeowners, which is great. But when President Obama stood before the TV cameras on that day, you know that no bank in this nation had any idea what he was talking about? He came out with us, says, I'm going to help them, and we're going to come together with a program. And nobody in the banking institutions knew anything about what he was talking about. And what they did was they scrambled. And so this modification program that you hear is not really a modification program. Modification programs are being forced upon the banks, basically, but the intent is good. Help the homeowner save his home. But key point number 2, whoever owns your loan is going to dictate the terms of any kind of modification program. Okay? For example, the federal program, the so-called homeowners, they call it HAMP, Homeowners Modification Program, or sometimes you hear HAFA, real exotic terms, HAFA, Homeowners Foreclosure Alternative. I mean, these programs are meant for loans that the government can intercede. In other words, the Fannie Mae's and the Freddie Macs of the world, they're under government control. So they can dictate that so-called HAMP program where you hear these exotic 2% rates, 40-year terms. They can dictate that. But if a loan is owned by, say, First Hawaiian Bank, the federal government cannot tell First Hawaiian Bank, you got to do this. We are the owner of the loan. So each loan, depending on who the owner is, have different modification policies. So what you hear from your neighbor that says, I got a 2%er, and then you talk to the guy next to him and says, well, I got 4%. Could be totally different scenarios because depending on who owns the loan, they have different modification programs. So there's not one program available, there's many programs out there available. Federal programs, private parties, Bank of America, Wells Fargo, you name it. Tons of them out there. No rhyme and reason who's going to get what. Okay? But you're going to hear all the various stories. Okay? That's modifications. Okay? Different programs for different people. We go into short sales. We cannot modify the loan. All of a sudden, we're going to tell the homeowner, hey, you know, we can't help you out. Would you consider selling your property? The realtor comes into play. Great news, right? You got new listings. Trust me, if you get a listing and you know that you have a so-called dispersed property going on, first thing you do is get some authorization from the customers to talk to the lender. Stay in touch with the lender, because you don't want that short sale program to all of a sudden get to the point where we have to end up foreclosure. You're going to spend a lot of money advertising. You know, you're going to spend a lot of time showing your property at open houses. You don't want to lose your commission based on a foreclosure. What you want to do is get that authorization. You want to stay in touch with the lender to the point where you might want to send them the listing agreement. Okay, you want to keep in touch with them. Don't call them every day. The lenders get pissed off. Do not bug us. Call us once a week, maybe. Call us once every 2 weeks. Keep in touch. Don't call us every day. It's not going to work. Okay, but you see what I mean, right? Stay in touch. We're in a short sale situation. We cannot do a repayment. We cannot do a forbearance. Modification don't work. We're going to tell the homeowner to go ahead and try to sell your property. Realtors get involved. Keep in touch. Right? Because hopefully you're going to sell the property and I don't have to foreclose and I can take a day off. Now, if you cannot sell the property under a short sale scenario, we're not going to wait a year for you to sell the property. Once it gets to that point where that short sale is going on, or we've told the customer to sell his home, you know, we're dealing already with a delinquent loan, a problem loan. It might be 2-3 months down the road already. Remember that our friends at the regulators are going to tell us, you got to do something while he's trying to sell the home. While it ain't selling, do something else. Next so-called loss mitigation option. You cannot sell it, the bank will. Or a deed in lieu. We will take a deed in lieu depending on the situation. But see, I find it really crazy. If you, the realtor, can't sell it, what do you think me, the banker, can sell it? I find that very, I mean, you know. Now, that is a loss mitigation process to accept a deed in lieu. Now, you as the realtor will have the job to, you know, sell this property both in a short sale situation, or you might have some kind of interest in trying to list the property with the bank because of the deed in lieu. Naturally, you would have a hard time trying to get the listing agreement in a deed in lieu because you had it prior to the deed in lieu and you couldn't sell it anyway, right? But let me tell you this. When you're dealing with customers, you have to be very frank with them, especially if you find out that you're in a distressed situation. Okay? Don't make promises that you can't keep. Both in the so-called short sale and in the deed in lieu, Everett kind of alluded to it. Deficiencies. We know that in a short sale situation, we're going to be short. We're not going to get paid in full. Will the bank forgive the debt? Remember we said different loans have different owners? It's the same scenario when we do both a short sale and a deed in lieu. The owner of the property or the owner of the mortgage is going to dictate whether or not we're going to waive the deficiency or we're going to collect the deficiency. And if we have mortgage insurance on the loan itself, now you got to deal with the mortgage insurance company. So when we start dealing with short sales and deeds in lieu, remember, different owners have different takes on what we're trying to accomplish, really to try to get as much money back to the bank as possible. So when you deal with customers, don't promise them that the deficiencies are going to be waived and you're going to walk away. Because in a lot of the situations, they are not going to walk away. They're going to owe somebody money. Although I have seen where people have walked away, like in certain transactions that I've seen mainland lenders approve, they've walked away. I guess 2,500 miles is too far for them to swim and try to collect money. But I have seen it done. But again, one neighbor here gets a waiver. This neighbor has a local lender, and he's not going to get a waiver done. Different loans, different owners, different policies. Now, in the final attempt, we cannot negotiate a so-called deed in lieu. We're going to end up in foreclosure, subject to Act 48. Okay. But from a lender's perspective, okay, Act 48, we kind of know the intent, but in the practical world, I don't think any lender is going to use non-judicial foreclosure as a means of foreclosing on their properties until certain issues within Act 48 are resolved. It's not so much the banks, but you know, again, bankers are lazy. We hire attorneys. You know, these two are attorneys, they know what I mean. But we hire attorneys to handle the foreclosures. And currently, right now, the attorneys that generally do foreclosures have told us they will not use non-judicial foreclosure as a means to foreclose on mortgages and collect funds.
Good.
So, generally what you're going to see now, and I think just yesterday at the task force meeting, we've seen an upward trend in the filings of judicial foreclosures from one year to the next. This is only first surface, but I can kind of surmise that everybody's seen an increase. How does it impact you folks? I thought I read something about a couple weeks ago, something that 22% of all sales locally were somehow foreclosure related. Something to that effect, 22% of all sales. Now, judicial foreclosure in the perfect world, 8 months total to complete. If we see a backlog in the court system, in the judiciary, and everybody is going to go to judicial foreclosures, sky's the limit. We don't know how long it's going to take to complete a foreclosure. Does it take 18 months?
Yeah.
Does it take 2 years? Does it take 3 years? We don't know. Depends on how many filings are done. The big guys, the Fannie Mae, the Freddie Macs, the Bank of America, they haven't rushed the court system yet. They haven't filed. So we don't know how many filings are out there. The local banks traditionally have gone on a judicial process anyway. But again, when you see some of the big boys come in, we don't know how much is going to be filed, we don't know how long it's going to take. Impact to the realtors group, I don't know what you guys would sell. There's not going to be any more REOs there. I think it's going to impact your sales. You know, we're talking, if I read and I remember correctly, 22% of your sales came from foreclosure-related entities. So you lose that 22%. First of all, Bank is not hiring, by the way. But trust me, I mean, I think it's going to impact the realty group. You know, when we start talking about numbers. I mean, there's a certain number of sales no matter what happens. But I think, again, 22% was the so-called volume related to foreclosures. And this thing slows down and everybody has to go and you got to wait 2 years for the next property to come out of foreclosure. I think it's going to impact us. So, you know, that's the loss mitigation process in a nutshell. Everybody kind of uses it, but depending on the owner of the loan, it varies. Okay? But the general concepts are all the same. Okay? And again, if you have any specific questions, let me know. We'll be around after the presentation. Okay? Thank you.
Next will be Gail Olson. Do you want to speak from here?
I'm coming up.
You're coming up.
Hello, everybody. Okay. What I'm going to talk about today is FHA insured loans. All right? Are anybody from the neighbor islands here? Okay, let me give you some figures from the different counties. This is effective as of this past Monday, September 12th. County of Hawaii, loans in default, 73. Loans in foreclosure, 8. Total, 81. Honolulu County, in default, 261. In foreclosure, 14. Total, 275. Hawaii County, in default, 25. In foreclosure, 3. Total, 28. Maui County, in default, 69. In foreclosure, 10. Total, 79. So kind of, the total is in default, 428 loans for the state of Hawaii and 35 in foreclosure, 463. So, you know, it doesn't sound that high, you know, compared to the mainland, but it's high for Hawaii, okay? So these are only FHA loans, insured loans. Okay. I'm going to talk about loss mitigation options, and this is only dealing with FHA insured loans, not conventional loans. Okay, so bear that in mind. First of all, I want to make sure you know that if you're working with somebody that has an FHA insured loan, loss mitigation is not an option for the lender. It's a requirement by HUD. Okay, they have to work loss mitigation. It's not a matter of they're 3 months behind, boom, they're going to start foreclosure. You cannot do that for an FHA insured loan, okay? Why do we do loss mitigation? Who does it benefit? Number one, it benefits the homeowner, right? Because they're going to try and keep the property, stay out of foreclosure. It also benefits the lender. Why? They earn incentives if they do loss mitigation options. They get money if they save loans. They keep their performing loans in their portfolio. It benefits HUD because we don't have to pay out claims, right? So big benefits for everybody concerned. The lender must evaluate each delinquent loan no later than the 90th day of delinquency to determine which loss mitigation option would be appropriate for that particular family. Foreclosure cannot be initiated until all loss mit options have been evaluated. So there are 3 options. The first is special forbearance. The second is loan modification. The third is partial claim. And there are also 2 disposition options. So if those 3 don't work, obviously, you know, they're not going to be able to save the property. So the first disposition option is a pre-foreclosure sale or short sale. And the second is, as Gary talked about earlier, a deed in lieu. Okay, so let's talk about the special forbearance first. It's a written agreement between the homeowner and lender which leads to reinstatement of the loan. So obviously, the goal is to bring the loan current. There's no maximum duration. It does not change the loan terms. It also provides in the agreement failure options in case something goes wrong. You know, what are they going to do? What's the lender and the homeowner going to do? And I should have told you this before, but I'm just talking about owner-occupant loans, right? Owner-occupant properties, not investors. The homeowner has experienced a loss of income or increase in living expenses. They will have sufficient surplus income to correct the deficiency within the duration of their agreement. It may be used to reinstate a loan to facilitate eventual sale or assumption. So, you know, say down the line, the homeowner wants to sell it or have it assumed. If you didn't know, FHA loans are freely assumable. That's a really big advantage of FHA financing. The accrued arrearage cannot exceed 12 months PITI, principal, interest, taxes, insurance. A financial analysis is done by the lender, and the special forbearance should consider property repair and maintenance. Because if the property is in disrepair, sometimes if they go into a forbearance agreement, you know, the homeowner cannot make the payments because on the side he's trying to fix the roof, he's trying to, you know, fix the leaks here and there. So when the financial analysis is done by the lender, repairs are also, you know, inspection is done of the property and to see if any kind of major repairs are required on the property. It also may be appropriate to provide a period of suspended or reduced payments to allow for property repair to be done by the homeowner. And it may be a special forbearance may be combined with a loan modification or partial claim in some instances. So that's the special forbearance. The second option is called a loan modification. And Gary was talking about Obama's loan modification or the president's loan modification for loans that are owned by Fannie or Freddie. This is outside of that, okay? So loan modification is a permanent change in one or more of the terms of the mortgage. Permanent change in interest rate, capitalization of delinquent principal, interest, or escrow items, and an extension of time to repay the loan. It allows the loan to be reinstated, resulting in a payment the homeowner can afford. At least 3 full payments have to be due and unpaid, and a minimum of 12 months elapsed time since the loan origination date. Income is sufficient to support the modified mortgage. So obviously, if we're going to do a loan modification, the lender has to make sure that the homeowner can afford the new payment. If the current loan is an ARM, it's got to be converted to a fixed rate interest rate. The use of the loan modification to reinstate prior to sale or assumption is not allowed. It's allowed for special forbearance, but not for a loan modification, because the idea is the family is going to stay there, stay in the property and keep the property as their principal residence. The loan may be extended not to exceed more than 10 years beyond the original maturity date or 360 months from the due date of the first payment under the loan mod, whichever is less. So that's a loan mod. The next option is called a partial claim. The lender reinstates the loan. The lender brings the loan current. But the amount to bring current cannot exceed 12 months PITI. A second note in mortgage covering the reinstated amount is issued in the name of the Secretary of HUD. Therefore, HUD will hold a second mortgage for the reinstated amount. Okay? The homeowner has a long-term financial stability to support the mortgage debt, but is unable to repay the arrearage through a special forbearance or a loan modification. The loan must be 4 months due and unpaid. The total delinquency, again, cannot exceed 12 months PITI. And again, it cannot be used to reinstate the loan if they want to sell it or have the loan assumed. And a partial claim can, in some instances, be combined with a special forbearance. But it cannot be used with a loan modification. So the second note is due and payable when the first mortgage is paid off, or of course when the homeowner no longer owns the property. The homeowner does not have to make monthly payments on the second note, not unless they are able to or if they want to. Okay, but they don't have to make payments at all until they either pay off the first mortgage, or again they no longer own the property. Okay, so now a short sale, pre-foreclosure sale. A PFS is considered, okay, so those are the 3, try to keep the property, right? But if none work, and the lender has to make sure that they've done their homework to make sure that, whether the homeowner qualifies for either of the 3. If they don't qualify for any of them, one of the disposition items is the pre-foreclosure sale. So again, the homeowner has to have the approval of the lender to pursue a PFS. So what they would do is try to market the property and obviously try to sell. So usually on a PFS, the value, it's worth less than what's owed, right? So for an FHA loan, who pays the difference if they're able to sell the property? Who pays the difference? HUD pays, right, exactly. It's paid by the insurance. Very good, very good. Let's see. There are certain restrictions as far as, value of the property versus net proceeds, but I won't go into detail on that. But that's a pre-foreclosure sale or short sale. The last one, if they can't sell the property, then they can do a deed in lieu. And Gary had talked about that earlier. The title must be free and clear of all liens. The loan must be at least 31 days delinquent when the deed in lieu is recorded. The homeowner does not own any other FHA-insured loans. So, in order to qualify for a deed in lieu, this is the only FHA loan that he has. It must be completed within 6 months of the date of default unless the lender has qualified for an extension of time trying a different loss mitigation option. And if a deed in lieu follows a failed special forbearance or PFS, then it must be completed within 90 days of the failure. So those are the loss mitigation options and disposition options for FHA insured loans. Thank you.
Okay, to wrap everything up, we will have Elizabeth Kent from Judiciary.
So life is like a box of chocolates is what Forrest Gump told us, and in our office, chocolates mean caramels. When a box comes in, we start looking for those caramels, and every once in a while we come across something that's oblong or square that we think is a caramel, but it's not. It's a cream disguised as a caramel. And there's a caloric cost to that, as well as disappointment in not having our expectations met. Whenever it talked about the DR, or dispute resolution sessions, being sort of like mediation, that's what I think of. A cream is sort of like a caramel, but it's not a caramel. And so what I'm going to talk to you about today is how it's different. My job is, you're all skilled negotiators, you're realtors. I think of you kind of with the MAD approach. You're the one that's helping somebody who needs help. And so I want to let you know what I think are some of the ways that you can help those people to make their sessions as effective as possible using the MAD approach. And clearly the best thing that they can do to prepare for their dispute resolution or DR session is to be prepared. And so let me talk real quickly about negotiation. I think of DR, dispute resolution, that's the acronym I'm going to use, under Act 48 as assisted negotiation. These are the elements that negotiators need to have a good understanding of, and they really need to think about these as they go into DR. Power is the potential to influence people or situations. One way that Act 48 is distinctive from mediation is that one person, that owner-occupant, has the power to compel the parties to come to that DR session. So that's very different than most mediations. But the power is also different for the neutral. And notice I'm calling this person a neutral and not a mediator. This is why, one of the reasons, the neutral at the end of the session needs to fill out a report. And in that report, the neutral needs to say if the lender or the owner-occupant failed to comply with the requirements of the DR program, such as they failed to give the required documents to the DCCA, or in the case of the lender, they didn't have an authorized person come to the session. And there's serious consequences and sanctions if the parties don't comply with the rules. Those include a stay of foreclosure, removal of a stay of foreclosure, and fines, and the fines can be up to $1,500. So real briefly, that's power. Timing includes preparation and negotiation time as well as acceptance time. And I think you know a lot about acceptance time. That's the amount of time that somebody needs to adapt to something that seems unacceptable at first. Anybody here married like me? Okay, so you know when your spouse says something in the morning, you think, absolutely not. By the end of the day, you know it makes sense. That's acceptance time. Okay, you need to understand the psychology of negotiation as you think about DR sessions. And time is going to be a really big factor in DR under Act 48. Often it's said that a good negotiation strategy is to start with the small things and then build to the harder things. The thing is, under Act 48 DR sessions, you can be assured of one session that lasts up to 3 hours. I don't think you're going to have time to start small and to build. And so you need to think about doing that. Parties may get a second session, but it's at the neutral's discretion. And incidentally, I'm not sure that neutral is going to get paid any more money for that second session. Just something to think about. As you're working with someone, they need to get their mind around what they need to be prepared to do. And I keep emphasizing 1 3-hour session. My experience in negotiations is that usually there's a lot of back and forth. I'm a lawyer, so in most lawyer negotiations, it seems like we go back and forth 2 or 3 times. Again, thinking about that 1 3-hour session, you're not going to necessarily have time to do that. So when you're helping someone prep for it, help them think about that dance. And if you're thinking about dating, what you should think about is speed dating. Okay, not regular dating. Think about the psychology of negotiation. Information about the substance and about the negotiation process is critical. You need to think about your party's needs. You also need to think about the other party's needs. And that great American philosopher Yogi Berra once said, you've got to be very careful if you don't know where you're going because you might not get there. Act 48 requires both parties to do certain things and to file certain documents. And the idea about that was to get people prepared. But my concern is that in and of itself isn't going to ensure adequate preparation. We have to put the human factor in there. I've seen how people act under stress, and often stress prolongs things. I see a lot of you shaking your heads. Again, sorry to bore you, but 1 3-hour session. There isn't time to have stress, and you got to be prepared before you go there. You got to be prepared for what you can expect. A lot of times I think people go to a dispute resolution session wanting to share their emotional things. And I don't think that there's going to be time for that under DR. Parties need to come prepared with a proposal to put onto the table. They need to think about why it makes sense for themselves and be able to explain why it makes sense for the other side as well. They have to have a plan B too, not just a plan A and plan B, and they need to remember that the parties approach it from different points of view. For the homeowner, it's certainly an emotional thing. Think about all of the happy things that happened in your house. But owner occupants are going to need to recognize that for the lender, it's a transaction. They're not going to want to think about or spend time on the emotional part and what the home means to the person. It is a transaction. Also, lenders are going to need to, I think, to be aware of how much stress the homeowners are under. The fourth factor is skill. And skill enables a negotiator to use power, time, and information in the DR session. Effective communication and listening are always good skills. I want to emphasize the skill of EQ, emotional quotient. And recently I heard such an interesting thing on NPR when this man was talking about this session that he was in. Everybody, it was a room like this, and everybody was watching the speaker, but he had such a good EQ. He was reading the speaker's body language, and he was reading what the speaker wasn't saying, and he alone, out of all of the people in the room, picked up on what wasn't being said, came out, made an investment decision, made a whole lot of money off of it, and the other people hadn't caught on, and it was because of his EQ. So I think that when you're working with someone, be sure to talk about looking at the whole situation, thinking about body language, thinking about your own, and using that as part of the skill. I think also sometimes you'll be working with people with spouses, and this is a situation where spouses need to be on the same page before they get into the DR session. They need to have a united front. keep the house and the spouse. So let's see. There's a lot that we don't know about what's going to happen with DR under Act 48. I've tried to give you some preparation tips to think about it. I tried to look into the crystal ball as we move forward. But here's the good news. No matter that we don't know now, we want to know from the people who are going to go through those DR sessions what's going to happen. So there'll be a questionnaire that's given to the participants at the end of the session. And I can promise you, I'm going to read those very carefully. Everett will too. And we'll be talking about what types of changes need to be made and making tweaks, because we really want to hear from the people that go through the process. So in closing, I think that Act 48 provides hope for borrowers and lenders and a process to help them work together. And with preparation, I think that they can make significant progress through effective dispute resolution under Act 48. Thank you.
Just for your information, this program will be on Owello. This is not a bunch of HAR's equipment. This is theirs. And so that'll be showing up, and HAR will be sending out on their site and let you know when this will be. Also, I want to make sure that when we have time to thank the panel, I think anybody that walked into this room an hour and a half ago certainly had no idea of the wealth of knowledge that the panel has presented to all of us. We are very appreciative of that. And we do also want to thank HAR for putting together this terrific panel to educate all of us. Now, we're really tight on time. We can ask for a few questions. Again, if that should be on point to the panelists with Act 48. Does anybody have any questions right over here?
Very quickly, I've never been sure. Is the mediation a face-to-face, or is it you and the other party are in two rooms, the mediator goes back and forth?
Are you asking about
The mediation process itself, is it face-to-face or is it like other mediation?
Yes.
So the dispute resolution process under Act 48.
Yes.
I think that the majority of them will be face-to-face. It's really going to be up to the neutral, though. I mean, as a neutral, I'm a mediator. In a mediation, I make a decision whether this is a case where I want to have people in the room the whole time, or that I think it would be more effective to have them separate.
Right.
So I can't speak for all of the neutrals to say that they'll have people in the room the whole time. I think
it's not mandated one way or the other. That's what I was curious.
Oh, okay.
Yeah.
Not that they're together. I mean, the intention is that you're going to have people there with authority so that you have the right people in the room who can make a decision.
Thank you.
I hope that answered it and not didn't go too long.
Yes, over here.
Can an owner bring an attorney with them, or is it just the owner on their own?
The answer to that is yes. The owner can bring an attorney. Quite honestly, we weren't trying to set up the process whereby the parties would be bringing counsel, but the idea was that whoever does show up has to have the authority to make a decision on a modification, settlement, deed, and whatever the resolution would be.
Okay, great.
Since I have three attorneys in the room, is there a statute of limitations on filing a deficiency judgment after foreclosure?
Did you hear that question? Is there a statute of limitations on filing a deficiency judgment?
I'm not an attorney.
You would be the one filing the deficiency judgment.
But generally, I mean, in a banker's case, we're not going to wait to file a deficiency. If the deficiency, if nothing can be worked out, a suit or complaint will be filed almost immediately to obtain the deficiency.
That's the question. Can it be 2, 5, 10 years down the road?
I don't know.
Well, I guess the answer is, short of wanting to give you guys legal advice, which is why all the attorneys are being really silent. There is a statute which specifically says how long judgments last. And if you just happen to hear that it's 10 years, that might be close. That's basically, it's the same thing like any other judgment. I think that's your question, how long does the deficiency judgment last? Is that your
No,
question?
but filing, not filing. The question is if they, can they file, at what point?
That's, as Gary said, I think it's really discretionary.
It's
up to the
discretionary.
lenders. Yeah.
But
And
again,
it has to be recorded?
Yes.
Deficiency has to be recorded?
Yeah.
Yes. Okay, next question. Any other questions?
Sure.
Yes, over here.
What about foreclosures being filed like within the last 15 days? And the law started on May 5th, but the reg starts October 1. What happens to people in between?
They're probably not, those are probably not insurable, which means they probably cannot be sold because the Part 2 is not ready until October 1. So if they started it now, they could probably not meet all of the requirements to satisfy Part 2. So it's probably not insurable. So if you can't get title insurance, you can't sell it, right? And not judicial, no, not affected. So they could file judicial foreclosure now.
Patsy, would you recommend that when anybody does have this type of question that they should check with their escrow officer before you get down through the process to make sure that it's you can actually close the transaction?
Yes.
I have time for one more question. Over here.
Gary, for First Hawaiian and the other local banks have been using judicial foreclosures all along. How does Act 48, how is that going to affect you?
Does, yeah, I mean,
Just the amount of time that you're going to be waiting for.
we made a conscious, well, again, I cannot speak for all the banks, okay, but generally, most of the local banks did choose to go to judicial foreclosure. I mean, we have gone non-judicial on occasions based on the customer situation. As an example, let's say you filed a bankruptcy, you were discharged from the debt. We knew we couldn't get any kind of deficiency. Doesn't make any sense to spend 8 months in court. We would file a non-judicial. But generally, most of the local banks, and I know for First Hawaiian, we chose to go non-judicial, and we eliminated all this controversy about whether the customer has a say in the proceedings or not. Okay, so we've done it. Does Act 48 really impact us? Not really, because again, our corporate culture says, hey, we're going to go judicial and give a customer a chance to speak in court if they want. So it's no impact on us.
Well, I think one thing we can say for sure, we learned a lot today. I think that it certainly makes a lot of sense if you're not positive, and I don't think anybody is, to ask the questions so they clearly understand what the rules and how the law will be applied. And again, I want to thank the panel, everybody was thinking.